Hello everyone and welcome to our government briefing, delivering it in a slightly different way this morning. I hope you're all staying safe and well in isolation, and we're certainly living in interesting times. This is my first virtual seminar that I've given under the auspices of government briefing, so we hope you enjoy the format. One thing to note that as we go through the session today, if there are any technical issues, we are recording it, so that if there is a technical issue, and I'm sure there won't be, but we'll be able to access the presentation at a later time. In terms of the Q&A function, we do have a Q&A function. What we're proposing to do, it's in the bottom right hand of the corner, and I would encourage you to send questions that you have as they may arise, and we'll have a team member. We have a team member online moderating those questions, and they will send them through to me, and I'll endeavour to get through them as much as I can. And the recording of this session will be circulated to you in the coming days. Going back to the Q&As, what I propose to do is just so that we can get through the presentation. I'll run through the presentation, but please, as I said, if you have questions as we go through the presentation, send them through at the time so that you don't forget them. And then at the end of the presentation, I'll then flick through and answer some of those questions. Just think doing it that way as opposed to going through the presentation and stopping and starting for questions. It's probably not a good way to handle this sort of a format. So today, of course, the presentation is about data privacy and record keeping challenges that have come up as we are in a COVID-19 world. What I will be discussing, I want to firstly, and there's a lot that we could talk about in this space. I think it's been one of the big themes that's come through as we've dealt with COVID-19. What I want to talk about for the presentation, firstly, I just want to touch on some of the key themes that are coming through that are being highlighted by COVID-19. Then, of course, I want to flick through what we're seeing in terms of some of the regulatory challenges with information handling practices that are arising, as we're working in a COVID-19 world, flexible working practices, collecting information, personal information because of COVID-19. We'll look at the really difficult regulatory issues that we're seeing come up in light of that, and we'll be focusing on information privacy and record keeping. I did also want to touch on Operation Impala. If you haven't seen that, that was the Crime and Corruptions Commission's report into confidential personal information as presenting a corruption risk. And I think a lot of the implications flowing from that report have sort of been swallowed up with COVID-19, but there's certainly some things coming out of that which I think are very relevant to managing corruption risks in flexible working environments in respect of confidential personal information. And the CCC has, during Privacy Awareness Week, has actually issued a release talking through those issues and managing those issues. So that is an issue which is front and centre with the corruption regulator, so I think it's important that we talk through that. What I then wanted to talk about is the COVID Safe app. I mean, that's probably been the biggest privacy issue that's come up with COVID-19. I didn't want to, go through the nuts and bolts of that app in a highly detailed way. But what I do want to talk about are the privacy protections that the federal government's set up and publicised, because I think one thing that we can take from the COVID Safe app is that the federal government has set the bar high in terms of the privacy protections that that's going to apply to this app. And I think it's sort of raising the bar, and I think to some degree might raise the bar in terms of public expectations about this sort of technology, collecting this sort of personal information, and what the expectation will be going forward as government around the country, obviously specifically in Queensland, move to digital platforms and collecting information through things like apps. So that's why I want to look at the COVID Safe app, and then I want to also just have a look at some emerging issues which I think have basically always been issues, but I think the pandemic and the issues coming out of that have sort of really brought these things to the fore. So just to touch on some of the key themes that we're seeing, one of the things that I think this whole the COVID-19 pandemic has highlighted is some key drivers and what the community thinks about when they're having to think about privacy, personal information, and the level of comfort that they have around government dealing with personal information. I mean, I think the first thing is trust. Everyone knows who practices in this area that trust is a major driver in terms of decision making that people apply, both in terms of whether or not they're going to provide that information, but what they think about, if they're going to complain. The level of trust that they have is critical. So what that means, obviously, for governments and agencies collecting personal information is that you have to make sure that you're operating. It may not always be operating in a trust environment might mean operating above and beyond the legal requirements. So if you're wanting to, say, collect information on a voluntary basis from people, going above and beyond the legal requirements to make sure that you have trust, those can be relevant considerations for you. And I think this environment, to think that people have consented to the level of information that the COVID app Safe, the app collects, is quite extraordinary. So trust is a critical factor. Context, privacy is also, and what people think about what's appropriate and what's not, is always about context. And so even if we think about COVID Safe and even the level of information that people may be providing to cafes, so you may have gone into a cafe and you're sitting there, you've got to provide details, or the level of information that you've provided to your employer if you've come into contact with someone who's tested positive. 9 times out of 10, if we weren't operating in the current environment that we're operating in, people would be not as willing, I think, to do that. So thinking about the context and why you're collecting the information and the context in which that's happening, I think, is really important. And the current situation has really brought that to bear. The next thing, I think the big thing, and it's impacting on all of us, some of it positively, if you're watching this presentation in your pyjamas, working from home, flexible working arrangements is not a bad thing, unless and until the day comes when you have to cast aside the elastic pants and put some work clothes on. But there's a range of that sort of flexible working practices, practicing from home. It seems to be the case that those arrangements are here to stay, at least in the sort of immediate to longer term, if we say, for the rest of the year. And they present, those large-scale changes that we've seen in a matter of months really do present some challenges just ordinarily, but in a regulatory setting in terms of privacy, record keeping, corruption risks. That's a major theme, and thinking about, and because we've had to do it relatively quickly, it may be that some of these issues haven't been properly regularised yet. So it's a matter of being aware of the risks and then acting on them and regularising the situation so that you're complying with those requirements. Another aspect to it is also, I think, that now that people are seeing and the way that the COVID app is being pitched, if you like, the real value and benefits and insights that can be obtained from using personal information for sort of broader community purposes. Now, I think politicians, agencies have been talking about that for quite a long time. And my view is that sort of recognition of the value there has often been behind the scenes. But I think people have now sought to sort of see that sort of information, that sort of data can be very useful. So that's another. So that awareness of the use and the benefit of that information, I think, is also something, as we move forward, we may be left with that, and that means, when people have a greater appreciation of value and benefits, they tend to have higher expectations about how things like personal information is managed going forward. So that's an interesting thing, I think, that's coming out of a theme coming out of COVID-19. Also, and this goes back to that trust issue as well, the importance of privacy by design, and that's something that regulators, the privacy commissioners, have been talking about for a long time. But I think, and again, as I said, it goes back to that trust piece, that privacy by design is really best practice. We've known that for a long time, but when you think about the things that when we're designing new programs or apps or something like that, it should always be on the basis of privacy by design, which means thinking about privacy considerations as you are designing, say, the project or the app, as opposed to designing it and then stepping back and thinking about a number of patches that you can apply to it to get regulatory compliance. You should be designing it with best practice privacy compliance in mind, as opposed to patching it up later. So that's privacy by design, but I think that's becoming more and more critical as we see the benefit of information, as we see the need for trust. These things are all sort of getting, I think, a real critical mass and being highlighted with the COVID-19 pandemic. That last point, as I said earlier, we'll have a look at the COVID Safe app, but really I think one of the things to take away from this app, the government's come out on the front foot because obviously the federal government wants people to download the app. They've told us about the benefits of it, but in wanting to entice us, for want of a better word, to download the app, they've, belted in, belts and buckle approach, a range of safeguards on the app. So really, I think the thing coming away from this is they've set the bar really high for what, what is a standard protection regime, and whether or not, I think if governments in the future are wanting to design apps that collect personal information, and if they don't have the level of protection that this app has, then there'll need to be some justifications, because my point is with this is that I think the government has kind of set the bar, set the ground for, what these considerations look like. So even if it's not going to be as intrusive, I would think that the community will have an expectation, okay, well, why is this app doesn't have this, but the COVID Safe one did, So that's sort of going out on the front foot, publicising these things heavily. That's what that can do. So I think we're sort of in a new world, if you like, about public expectations about what sort of privacy protections will now be included in that sort of platform, or any government program really that's sort of collecting information. So that's the sort of I think the context and the framework and the themes that are coming out of COVID-19 with privacy and data handling and record keeping. But there are some clear regulatory issues which I wanted to touch on now. And one of the things that has been, highly visible is that employers, and this is obviously for state government and local government officers, has been the collection of let's call it COVID-19 related information, in order to sort of promote programs, to make sure that workplaces are safe. So, people have been asked to disclose very early on as well if they've been diagnosed, if they've been tested, if they're living with someone who is in a high risk category, a range of information, and quite intrusive information that we may not have seen collected before. And as I said before, why they're doing it, they're obviously, government has an obligation to its employees to make sure they have a safe working environment. So that means that people need to be tested. need to make a disclosure in some instances if they've tested positive, and provide other information about family and living arrangements or travel arrangements that they may not ordinarily have provided. So there's a whole new sort of level of detail of personal information that the state, local governments, a range of people have been now collecting in order to sort of provide a safe place of work, or to, if government's a service provider, to make sure that people accessing that service are doing so in a safe manner. So, a whole range of information that's been collected that we wouldn't have seen collected before. Some regulatory issues or key things or risks to note with that. You only agencies, if you think about the IPPs and the MPPs, you're only collecting what you need. Make sure that you do that. If you are asking someone about travel arrangements, for instance, have you been to a country that has, or if you're collecting information, have you been to a country which has a high risk? Well, that's fine, but make it so that you don't get the whole entrails of, say, someone's holiday, and you're collecting that and you're keeping that information, because the thing with collection-related requirements and only collecting what you need in terms of the functions that you have, none of these obligations can be complied with by consent. So unlike, say, use and disclosure obligations, an agency can comply with that by consent, but these ones you can't. So even if the person is giving you a range of personal information that you haven't asked for, there is a risk that if you actually physically collect that and you keep it, you've actually collected information that you don't need, and it doesn't matter whether or not it's been gathered in a consensual arrangement. So that's the first thing in terms of the regulatory issues to note. And of course, and we all know why, like once you get personal information, only collect what you need, because the regulatory compliance burden that sits with that information is high. So as a first, irrespective of the actual IPP1 and those obligations relating to that, from a practical perspective, given the burden of regulatory compliance, you should only really be collecting what you need. And also, but I think the key thing is also, like this trust element and this transparency element, is making sure that when you are asking for that information, it's fairly clear what you're asking for, so that, one, you don't get into a position of over-collecting, but secondly, it builds on that trust component that we spoke about before, that you don't want to have a situation where someone provides you with all this information and they walk away thinking, oh, well, hang on a second, why did I provide all that information? I don't know why, I just got to, you don't want to be in a situation where people are doubting when you're trying to engender trust, where they're doubting, why they gave you that information, why it was necessary. All of that should be upfront, particularly if you think about the type of information that in a COVID world that people are disclosing, sensitive health information, their family and living arrangements, those sorts of things. So even if we're not, before we even get to the regulatory regime, if we're talking about trust, transparency, we need to be making sure that, that at that collection point, that's all, transparency is there and there's an understanding of why you're collecting it. One interesting aspect to note, and this is for health agencies, if you don't need personal information for a particular purpose, you need to take reasonable steps to ensure that that person is not identified if it's no longer in use. So again, it sort of highlights the fact that don't collect it if you don't need it. One of the other key things with storing, and this then sort of mothballs into use and disclosure type concerns, is the commingling of COVID information. So, and what I mean when I say that is, if someone provides to you like a diagnosis or their family living arrangements in respect of, COVID-19 safety concerns, you should be very careful that that information doesn't find itself sort of mixed or commingled with your standard personal information holdings. Or if it does do that, you should make sure that there's a way that you can pull it back. Now, I sometimes liken that trying to sort of pull personal information out once it's collected to, trying to get chewing gum out of carpet. It's a really difficult thing. But the reason why that's important is that quite often you've only collected this COVID-19 information for a particular purpose, which is dealing with the pandemic. And usually there's a time frame with that, because it's dealing with the pandemic, and you've only done that to manage the pandemic, so that you've only collected it for that particular use. So 4 or 5 years down the track, if this gets commingled with other personal information, there's a real risk that you might be, say, someone's living arrangements, that you might inadvertently use that information for another purpose, despite the fact that it was provided in order to to deal with COVID-19 risks. So agencies need to be, and that's a very difficult task. I can appreciate that, because someone makes it or gives you that information, you can't just silo it, because you need to read it with their employment records or store it somewhere, because sometimes that's the only way it's going to be able to make sense. But that commingling, I think, is probably one of the highest regulatory risks with privacy that we've got, because, 2 or 3 years down the track, if it's not disposed of and not sort of flushed out of your information holdings once it's been used for its purpose, you then get to considerations of it being mixed, and you can't delineate between information garnered for this purpose and another. And you might sort of be in breach of use and disclosure requirements. And then there's that trust element as well that comes into the piece, that, people have given you this level of detail about their lives so you can deal with COVID-19 issues. If then down the track it's used for another purpose, then that's a complete breach of trust, aside from the regulatory issues, which, creates difficulty moving forward with the community when you've got other privacy issues that you need to deal with. So if you can separate it out, or at least know that this is, and again I can appreciate that is an incredibly difficult task, but that's really the key regulatory risk I see, is handling that information, dealing with it in a way that you can separate it out when the use for it has been exhausted. So when the pandemic's over, that sort of thing. So that because the risk there is, of course, that it will be used for different purposes from which you obtained it, and you'll be storing information that you don't need. So that's probably the first aspect that I would note. Probably the key regulatory risk here is that commingling, and then if you don't sort of destroy the information or pull it out once its purpose has expired, you then get into use and disclosure and all sorts of risks under the regulatory scheme. You might also say that, that sort of detailed, invasive information about a person, that's the sort of information that can largely be accessed in an unauthorised way. And that's a corruption risk that, I said earlier that Operation Impala had really highlighted that. So that's something also, that having that information when you don't have to have it, you can expose yourself to this sort of risk. One of the problems, though, with COVID-19 data is how long it's going to be kept. And we've seen that question, like if it's been kept to deal with the pandemic, that's how long is a piece of string? And that's one of the concerns that people have raised with the COVID Safe app, is that it just says, well, it will only be used and active during the course of the pandemic, but no one really knows why or how long that is. And we can understand why you can't define that, because we're living in unprecedented times. But that's, again, that uncertainty creates a compliance risk for you. The other aspect is, a lot of the information that we do have from the pandemic, people will want to keep it. We will want to keep it in the sense that it's incredibly informative. But we might need to think about de-identification if we haven't got the consents in place when the information was collected and we've not got the capacity to go back. Like if we've got a large set of information, we might not have the capacity in administrative terms to go back and seek consent. This sort of taps onto what I was talking about before. It's actually the enunciation in terms of IPPs 9 and 11, NPP 2. It's about the use perspective, the use point. And there's a raft of exceptions that this type of information has been gathered under and used in terms of, responding to emergencies, public health, those sorts of emergencies. But importantly, those types of exemptions are usually ones which there's an immediacy to. You need to use that to deal with the threat. And of course, the pandemic needs to be, what I would say, on foot for those exceptions to continue to be responsive to the use of that type of information. So again, make sure that if you've got information like that sort of stuff that I referred to earlier, and you're storing it, you're using it, and you've done so under the auspices of it being responsive to those types of exceptions, you need to actively check that they are still responsive, particularly if you get at a time frame where the pandemic's been is near its end. What that looks like, I don't know, but it's something that you should be monitoring to make sure that you can still continue to use that information for that purpose. If you're relying on that exception. I mean, if you're not relying on those sort of emergency, or even if you're relying on the exceptions, if there's been like a public health type declaration that's been made, and the information's been used or disclosed under those sort of authorised or required by laws, once those types of instruments expire and you've been using that information relying on that type of exception, you need to go back and check it. And it's always the thing where if you collect information, if you use information for a purpose that's connected to an event, so here COVID-19, it's always a risk that you need to be checking that event is still current, and that those exceptions that may have been relied upon, which are intrinsically connected with that event, are still current. And again, that point about it being commingled, I think that's probably, as I said before, the key regulatory risk, to make sure that if there is commingling, you can deal with COVID-19 data appropriately. So they're the key, and there's some more detail in that slide about those types of exemptions that I referred to earlier. And the key point again is, even if you've got exceptions that you're relying on, the other issue here, and I've said it before, is about trust. So you need to be making sure that if you've gotten it for a COVID purpose, you've told people that's why you've had it, and you need to make sure, obviously you need to do that in the regulatory setting, but as a question of trust and accountability, you need to be mindful of that and not breaching that trust, because that will pose significant challenges for you going forward. Next time there needs to be a collection of personal information of any sort, and particularly, stuff for sort of to inform rapid responses like what we've had to do with COVID-19. So they're the sort of, I guess, the privacy related, like the key ones. I mean, there's a range of other things that we could talk about, but they're probably the key risks that we can go through in the space of an hour. The other risks is record keeping, and normally when you start talking about record keeping, this is the time of the presentation when people start falling asleep or walk out of the room. But record keeping is incredibly important, and as you would understand, if we're working in a flexible working arrangement, it's important that those sort of arrangements that we've had to live under don't mean that our public record keeping practices suffer as a result, because the first thing is that, I mean, agencies need to be doing that, but also if you're dealing with information, documents, public records that are about the pandemic, they're actually incredibly valuable documents and information that need to be kept because they're incredibly informative as to how, you know, the Queensland government, the Queensland communities responded to this risk. And it's something that, you know, will be called upon by other future generations. So on that note, we should be making sure alone that we're keeping those documents and we've got practices in place to do that. And the State Archivist has put out material, guidance material about, you know, the record keeping risks and requirements and how they flow in a COVID-19 world. And they've basically emphasised as well in doing that there's no sort of, I guess, let off or taking the brake off the need to comply with those requirements because flexible working arrangements or working from home arrangements apply, because there's nothing in the Act, in the compliance framework, that actually allows you to diminish those obligations because, for instance, you've been working from home. So if we think about those sorts of arrangements, or, you know, think about record keeping and what the COVID-19 pandemic, the challenges that it's presented in terms of working flexibly, working from home. First thing to note is, for a lot of agencies, or at least a lot of clients that I've been involved with, have noted that sort of change and the move to that change in working practice happened very, very quickly. And so it may be the case that the organisation hasn't had the time or the capacity to properly set up the architecture and infrastructure that's needed to be set up, including security measures, to quickly work and roll out working arrangements with people working from home. That might mean, for instance, that employees might be using private emails, saving documents on their home computers, and using networks also that are not secure and so are more liable to cyber, or have a greater cyber risk rating, and also things like handwritten notes. You know, if you're on a teleconference, you're writing notes about what's happened on that teleconference. That's obviously a public record. And if you're doing that from home, you know, there's concerns about, well, are we making sure that we're properly capturing those records? I mean, I know myself, I'm not obviously in the public sector, but my record keeping, certainly with file notes, I've had to be quite diligent about that because, you know, you sort of do the file note and try to file the document somewhere, and it can sometimes get lost. So those sort of issues, I think, increase the risk of, you know, public records not being captured if you're using private email addresses or you're saving things on your home computers. There's public records are being unlawfully lost or destroyed. There might be breaches of employee guidelines, and the other concern is that there's you know, misconduct or corruption risks increase because, for example, your networks aren't as secure. You may not be working off the information system or architecture of the agency, so there's no audit trail about who's accessing documents and when. So the sort of capacity for inappropriate use and access to information is dropped, which means, you know, you've got a corruption risk. So there's a range of sort of what I would call record keeping things that come into play working in this environment. So key things, even if you're using, say, a private email address and you're using that to conduct government business, we have seen from the recent, or the Minister Bailey example, that, you know, there is an onus to make sure that that sort of record is kept. So if you're using private email accounts to conduct public sector work, and I know that there's been directives put out about the appropriateness of that sort of arrangement, but that may have had to have happened in the environment that they were working in now. But there should be proper processes to ensure that those types of documents are being routinely saved back to the to the record keeping infrastructure or architecture of the agency or the organisation that person's working from, and that includes emails going, forwarding emails back to your government email address if it's emails that you're using, making sure that if you are saving a document locally on your home computer, if you have to do that, and this is all on the assumption that you have to do that, because the preferred position is, of course, that you're not doing that, but you're making sure that that document is being saved back onto the system, particularly if you're moving from versions and you're making substantive changes, not just sort of grammatical or minor changes, because that evolution of the document, if it's substantively changing, each version of that is a public record. So there needs to be diligence about that, and also, of course, your hand written notes, and the key thing with this is, of course, that under the Public Records Act, there's obligations on the head of agencies to make sure that public records are being collected, they're accurate, they're up to date, they're being maintained. And of course, if you're working in this sort of environment and you're not working necessarily even partially or completely on your work infrastructure, these are the sort of risks that could come up and end up seeing your agency breach that requirement. The other aspect with COVID-19 records, and this sort of comes into also interacts, I think, with the Privacy Act, is making sure that you've got like your retention and disposal schedule is reflecting that you've got this new information in, or that there is at least an existing category that's in your retention and disposal schedule that can accommodate COVID-19 type information, and that the sentencing period or the period for which you've got to keep that document is accurate. Because, of course, if you are in a position where you're destroying COVID information that's a public record, that's a criminal offence under the Public Records Act. So there needs to be some thought applied. If you've got, you're creating new records with COVID-19 information, which you wouldn't ordinarily, accommodate that into your standard record, particularly your retention and disposal schedule, you need to think about, well, how are we going to deal with that so that we're not breaching Section 13. So there, I think, in terms of privacy record keeping, I mean, the privacy issue, I'll just go back with that, is, of course, because privacy will require you, if you've got an obligation to say, well, I only want this personal information. If you've collected it on the basis that you're only going to have the personal information until the pandemic is running, so to speak, you need to make sure that that can fit and work with your public records requirements. Because if that is a public record, then it will need to be kept, and it will need to be kept in accordance with your retention and disposal schedule. So it's almost like you don't want to necessarily promise the world in terms of when you can keep this type of information unless you can back that up in terms of your retention and disposal schedule. Because it might be that you can't yet, it might be in the community's mind that the pandemic's over, but there might be reasons under the Public Records Act why you have to retain it and keep it, which can cause some conflict. And, we're trying to operate in a trust environment that can be difficult, let alone the regulatory issues that sit with that. I did very briefly want to touch on just Operation Impala, just two things, because I think it's a major piece of work in terms of the Commission. I mean, we've always known that confidential government information is a clear corruption risk, but with Operation Impala, the Commission has sort of really highlighted that confidential personal or personal information of a sort of a highly confidential or confidential nature in itself presents a corruption risk. And that seems to be, not only that recognition has been triggered by the fact that the Commission appears to be seeing more and more instances of the inappropriate access, use, disclosure of sort of personal information. I mean, we would have all heard and seen of those issues in terms of police officers inappropriately accessing police records. That's been borne out, of course, publicly in a QCAT case. There was a report of a similar instance happening last weekend that was reported in the Guardian, if anyone's picked that up. So the Commission now is seeing the connection. I mean, it's always seen it, but there's a clear from a regulator a statement that this is a live corruption risk, and they're very much attuned to it. So, and that's what Operation Impala is about. And that there's 18 recommendations, some of which include like an action for a breach of privacy. So it's an extensive report. But the Commission also, sort of on the back of that, has released a note to say that flexible working arrangements present themselves challenges for agencies in managing corruption risks with confidential personal information. So, and those risks come up in that flexible working arrangement or, working from home because, you're less inclined, or there's a greater risk that you're not storing confidential information appropriately. Agencies, that auditing role and function that an agency would normally have about who's accessing information systems and why may be broken or partially visible because people are working, they may not all be working off the system. They might be, storing documents locally. Cyber risks are increased because you may be relying on home networks or providers where you don't have as much a secure network to be working off. And obviously to deal with that, I mean, it's been difficult to sort of respond to that in the timeframes that we've had, but it's about obviously clear expectations, procedures, making sure that, people are properly saving documents, those sorts of things, audits where you can, and infrastructure to deal with those. I mean, to deal with secure networks. I mean, we've all been given a different authentication requirement now where you use your phone and your computer because of the increased cyber risks with COVID-19. So just be mindful of the fact that, I guess, that the fact that these sort of settings that we're working in now and the change that they represent and the fact that those changes can increase the corruption risk has not escaped the focus of a regulator like the Crime and Corruption Commission. So I think it's incredibly important that even though, obviously the focus is on the pandemic, dealing with the pandemic, but it shouldn't be that these issues are completely brushed aside, and that if, for instance, you have got a gap because you've had to quickly roll out a working from home arrangement and you haven't gone back and checked these things, I think you'd be in receipt of poor advice if you didn't, make those changes and go back and make sure that you're putting in place measures, because this, the archivists have said that there's no change because of working from home, those obligations apply, and now the corruption regulator has basically said, well, in fact, if you don't have adequate systems and procedures in place to respond to these circumstances, you've got an increased corruption risk on your hands. So the COVID Safe app, as I said, I don't necessarily want to get into the sort of the nitty-gritty about how the app, the broader discussion about how it works and the purpose of it, other than sort of skimming over the things that we know about from the media, that the purpose of the app is to assist with the tracing and identification of people who have tested positive and the people who have been around them as a means of stopping the community spread of the virus. It's actually the state and territory health officials who will have access to this data, and it's come from a range of international models, including Singapore. So I've sort of set out the process at a high level in the slides. But the thing I think that is really interesting, and the thing to note with with the COVID Safe app is the privacy protections that the government has expressly noted and publicised in terms of this app. So we can see it's enshrined within legislation, the Privacy Act, of course. The Australian Information Commissioner has oversight of it. I mean, some of these things aren't new. And you might say, well, the fact that they were enshrined in legislation, that's not new, and we've seen privacy breaches from agencies and the federal government despite that. But there's other things. Data is encrypted using a privacy by design approach. The impact assessment, privacy impact assessment was publicly available, the source code, and the data must be deleted at the end of the pandemic. Like, that's actually been wedded into the Act. Now, when in fact that is, we all understand why it might be difficult to define when that is, but there's been some concerns about that. But you can see that from the thing that I think is interesting to note about the COVID Safe app is that I think going forward, this will be the benchmark, if you like, for what agencies, in terms of justifying these sorts of tools to the community. The community, I think, will be, it's a reasonable response if another government agency was to sort of, in the future, set up an app or want to digitise something, as we've seen here in Queensland, that the public would start to ask questions, okay, well, why have you not done this? Why have you not published the privacy impact statement? What about the source code if it's an app? So I think agencies need to be mindful of that fact when they're going to be putting up apps, new technologies, and then trying to justify that to the public. And particularly, I think the interesting thing is the privacy by design. As I said earlier, that's a key theme and really a critical approach to best practice, but also I think trust, genuine trust with the community, because you've thought about the app or the program with privacy in mind, as opposed to a compliance step that's taken, 6-7 rungs down the ladder when the program or the app is operational. I then, just so that we've got enough time to, so before we get off this topic, that's, I think, the message for us. I mean, there's probably people in this session who may very well be dealing with information from COVID Safe, and they've got some particular regulatory issues and concern that sit with that. I didn't want to necessarily talk about that here. But I think it is incredibly interesting to note that that's sort of the high watermark, I think, and the benchmark. And we know why, the federal government wanted people to take the app up. So they've said, well, look, we've got nothing to hide. We think it's a good system. But anyway, here's all of these measures that we think make this incredibly safe. So, as I said before, I think if you are planning on putting something similar up, for instance, or an app that's collecting information from people, I think at the very least now, given that we've seen this with this app, you need to be ready for questions and expectations from the community that this is the new benchmark going forward. Some emerging issues, again, just so that we've got time for some questions. I think the questions about remote working and working from home arrangements, I mean, at least even in our offices, there's a lot of talk about when we will 100% be back in the office, and whether in fact we've demonstrated to ourselves that we don't actually mind working out of the office on some days, and whether or not we'll continue that practice going forward. And that's all well and good, but I think if that is going to be an ensconced practice, then we need to obviously make sure that we've got appropriate systems in place to deal with, for instance, record keeping and those sort of increased corruption risks that may sit with those types of working arrangements if those systems aren't properly regularised to reflect the differences in, working remotely as opposed to working in the office. higher expectations on governments around data privacy in general. Normally, and I mean, I think it's fair to say we saw a sort of almost like a peak of public interest and concern around privacy after the mandatory data reporting arrangements were put in place, even though they took a long time to get there. But when they were finally enacted, there was a lot of community expectation and just discussion generally about privacy. And I think here what's happened is the fact that people have seen the benefits of or how our personal information can be used for public policy, public administration, community safety. People have become aware of and acutely aware of how valuable that information can be. And they've also seen that governments have raised the bar in terms of what they think are appropriate safeguards. So I think higher expectations coming from an awareness about privacy, the benefits of data, and then what we've seen with the COVID Safe application or app. Privacy by design, I think that's always been best. We've always known, privacy practitioners have always known, and regulators have always said that privacy by design is the best approach. But I think that when we're operating in this environment of higher expectations, greater concern, greater focus, I think privacy by design comes right into the fore. And I should say that these issues, a lot of these issues, they've always been around, but I think that the COVID-19 pandemic has really highlighted and brought to the fore these types of issues and sort of have meant that we've had to deal with them now where it may have been, a couple of years down the track. Certainly with this point about the deficiencies and challenges with regulating information privacy and privacy. I mean, people who deal with in this area would routinely know that the fact that we have a federation, the Commonwealth state interaction is routinely a problem. Multifaceted regulatory settings and overlay for personal information. You've got privacy, information privacy is being regulated from the perspective of sort of competition and consumer issues. It's also being regulated through information privacy and your privacy commissioners. And questions are abound about, well, is this too much? Is it a bit schizophrenic? Do we need a more holistic approach to privacy regulation? As I said, that's been there. Those issues have been floating around for some time now, but the pandemic, I think, has kind of brought these issues in greater focus. Issues of informed consent, again, not a new or novel concern, but that concern has been increased the more and more usage and different purposes we have for personal information. For example, future use and say the use of that personal information in AI and AI decision making. How can we possibly say that where consent is informed if we don't actually know what purposes that information will be used for in the future? And then, of course, data sharing, regulatory frameworks, the prevalence of secrecy provisions when you're trying to share data. But I think also the other thing with data sharing, and this is something that, is obviously, people practicing this area would know that secrecy provisions, data sharing are always an inhibitor. Some would say they protect those things. The other thing that I think is relevant about secrecy provisions is quite often they've been drafted so that it's more represents almost like a one-off consideration of whether or not the data or information can be disclosed, like the exceptions are drafted with that frame of mind. So it might be, if an officer has a reasonable expectation that the information is necessary to promote health and well-being or something like that, the exception might be drafted like that to the secrecy provision. And that sort of drafting, there's always questions abound as to whether or not that will hold up where you're sharing a data set of, 50,000 entries and whether or not a person can form a reasonable expectation that those purposes will be met when you're exchanging that volume of data. So I don't think, and again, I think the focus on privacy has sort of highlighted these issues. So I think in the next couple of years we'll certainly have to deal with them more and more. So that is the end of the presentation. So I did want to go through, I'm very minded to finish on time, and there's about 5 minutes for questions. So I might go through, I'll start from the top. Jennifer's asked, what obligations will government entities have to dispose of COVID-19 information once the risks from the pandemic have passed? How should that be demonstrated? Well, I think if we think about it in a privacy setting, that sort of destruction should occur once the risks have passed, like almost immediately, because that's the basis upon which the information has been collected, but that time frame sets the conditions for which it can be used. So you would expect that you wouldn't be able to use that information beyond the expiry of the pandemic. But the problem is then with record keeping, that information may be acutely relevant for, like it would be a public record. So it would be a question of, I think, almost a conflict in some respects about, because some of that information might be incredibly valuable to inform, decision making for the future, and it might be that the record itself can be disposed of, and your retention and disposal schedule would need to match that. But maybe you could think about de-identifying the data or something like that, so that you don't have a clash with privacy considerations. There's also a question about whether the State Archivist has released a retention schedule for COVID-19 related documents. I haven't specifically checked that point, but I know that they've released sort of a guide or a statement about record keeping practices persisting and not changing through flexible working arrangements. So they may not have done that, but it would just be a matter of going onto the website to check that. I've got an anonymous question. If employee A discloses that they have been tested for COVID-19 and they've been required to isolate, how can we keep their co-workers safe while also managing A's privacy? So that's a really good question, and I think that's something that we've been involved heavily in with public and private sector agencies trying to work that through. It's very difficult because, and particularly there's actually no way on one level of disclosing that if someone's isolating and they're not in the workplace, for instance, or they're isolating and so they can't come back and forth to the workplace, and that's known, that, or at least that then they're not able to come into the workplace. You can put two and two together and think, oh, well, they're not coming in or they're isolating because of the diagnosis. I think all that you can do in those circumstances, and in those exceptions that come into play about disclosure for community safety benefits and those sorts of things, they will normally respond to this type of scenario. But I think, and how we've advised, is that you, as much as you can, say, well, we're not able to disclose the fact or why that's occurring. Now, of course, if you have to, if there's been contact in the workplace and you have to disclose to other employees that diagnosis, then you have to do that. And it may be that unless you have to identify the person, you don't. But 9 times out of 10, people, particularly if it's a small workplace, they'll be able to identify who the person was anyway. But I think the principles are, where you can de-identify, If you can't, and if you're purely looking at this from a compliance perspective, those sort of the exception that looks at community safety is usually responsive to that type of scenario. We've just hit 1 o'clock, so sorry if I haven't been able to get through a question that you've put up, but as I said earlier, the presentation will be has been recorded and will be released, sent round to you in the next week or so. Thank you very much for joining the presentation. I hope it's been informative, and I hope the session has run well, given that this is the first virtual session that we've done. So thank you very much.